Hello, my name is Kathleen Flynn from the law offices at Kathleen M. Flynn, LLC in Decatur, Georgia. We assist children and adults in obtaining SSI benefits, which are welfare benefits, SSDI benefits, in which you have to work 5 out of the last 10 years approximately, and pay FICA taxes from your employment, disabled adult child benefits, in which you can collect on a deceased or living parent's record if they've paid into the Social Security disability benefits or Social Security retirement, as well as widows and widowers benefits who are age 50 to 59. We don't assist with those 60 and up because they don't have to show they're disabled and they don't need us. Child insurance benefits or veteran service connected benefits. Today I'll be discussing another way you can win your Social Security disability case. Now, most cases are won at step 3 or 5 of the sequential evaluation process. Step 3, and more of these cases are won at the initial and reconsideration level based on medical listings. And you can Google Social Security's website and look at your particular condition and see if you meet medical listing. Because they have doctors on staff at the initial and reconsideration level, that's how most cases are decided at step 3. I was told this by a former director of Disability Adjudication Services. At the hearing level, most cases are won at step 5 of the sequential evaluation process. Not many medical experts are used at hearings, and almost every hearing except a child hearing, and that's anyone under age 18, would have a vocational expert. So again, at age 18 and up, there would be a vocational expert, and based on a combination, if you have both mental and physical limitations or each one separately, the vocational expert will look at your past work and any skills to determine if they're transferable and decide based on your limitations whether jobs you can do. But today I'm going to tell you about a profile, and there are a couple others that I'll discuss in future videos, that most attorneys don't address in hearings and argue before the judge. And that's Social Security ruling 82-63. Just gave that a double check. Social Security ruling 82-63. What this ruling requires is that you have a marginal education, and Social Security defines a marginal education as 6th grade or less. And usually people with the 6th grade education or less don't have highly developed math, language, reading skills, so that they could only do unskilled jobs, which is the second requirement of this profile that could render you disabled, and that's unskilled work. Unskilled work is defined by the Social Security Administration as any work which was learned in 30 days or less. And of course, a vocational expert would evaluate the job you have and look at their materials such as the Dictionary of Occupational Titles, and also review what information you filled out in a work history report or testified to at a hearing. So once you've established that you have a marginal education and you've also established that you've had unskilled work, you have to show that it's been performed 35 years and that it was arduous. Now the ruling 82-63, you can refer to it for the definition of what arduous means, but again, that's left up to the adjudicator and the judge to decide. Looking at this ruling, they consider strenuous work that involves stamina to be arduous. And that doesn't necessarily mean you had to lift 100 pounds. You could lift 20 pounds but have to do it repeatedly, so that it involves a lot of stamina. Or you would have to bend repeatedly, or you'd have to perform tasks at a rapid pace. So if you have arduous work, or you think it's arduous work that you've performed in the last 35 years, you're going to need to detail all that in a work history report. Even if we were to go to a hearing, we'd have to have that in writing for the judge to review ahead of time, because it would take quite a bit of time to go through 35 years of work, unless it, were a couple jobs. Now, the Social Security Administration gets a detailed earnings report, and a lot of times that just has the headquarters, and some of my clients don't recognize the jobs based on, if I go over it with them, the headquarters locations. So you have to do the best you can in trying to remember these jobs. And don't forget that you could be found disabled if you meet this profile. And just to reiterate again, you have 6th grade education or less. You have 35 years of arduous, unskilled work. I remember I had a hearing with the judge, and the client actually had unskilled work, and the judge got the vocational expert to testify that the work was semi-skilled, because there was a little confusion about the way the client detailed it in writing, and it came out to be more of like a pipe layer, and all he was doing was digging ditches for people that were laying pipes. So you have to be really careful about your description and the details that you provide to show that indeed it was unskilled or it was arduous. Lastly, you have to show that you have a severe impairment, which is a very low threshold, basically a medical condition that's expected to last 12 months and interferes with your performing basic work activities. You have to show that you have a severe impairment or impairments which prevents you from performing this arduous, unskilled work that you did in the last 35 years. Then you could be found disabled pursuant to Social Security ruling 82-63. If you have further questions about this, feel free to give us a call at 404-479-4431. We'd be happy to help you with your disability case or answer your questions. Our website is www.kathleenflynnlaw.com/we-care if you want to send us a direct request in writing. Otherwise, you can just visit the website at www.kathleenflynnlaw.com. We will have this information at the end of the video too on a slide, so you don't have to write it all down very quickly. All right, well, thank you for taking the time to watch this video, and I hope you have a nice day.